Hi, and welcome back to my channel. So somebody made a request. I do a video on relevance. Okay, so I'm gonna use our book, a commentary on the Evidence Act by what's his name? Steve Ouma. I hope you can hear me. So okay, we're just going to go through this together. So basically what you need to know is that not every evidence, there are rules and conditions for admissibility, and that is evidence that is relevant, one that is admissible. So you must know what it means when we say evidence relevant or a fact is relevant. So that is page 28 of the book, A Commentary on the Evidence Act by Steve Ouma, second edition. And we are going to refer to the Evidence Act, of course, which is the primary statute. Now, there are many types under the Act of relevant facts, what they define as relevant facts, and we are going to go through them. So when the first thing that comes to mind, I remember from undergrad, is res gestae. I don't know if I read that correctly. Those are facts which are so connected to the relevant fact. So connected to the facts in issue as to be relevant. And that was like a song. So it's not gonna be anything extraordinary, just simple definitions of relevant facts. Now, we have facts which are, of course, facts which are related to facts in issue. Okay, it's just basic common sense, but let me just compose myself for a minute. So we have facts which are, okay, which are connected with a fact in issue. So connected in with a fact in issue. So we basically look at connection with the main issue. Sorry about noise. I don't know what these people are doing close to midnight outside, but hey, every monkey has their own circus. Anyway, so we have facts which are so connected with a fact in issue as to form part of the same transaction. So the words we are looking for are those facts which are, although not in issue, are so connected. So we have a connection, that is the first. Second, we have what we call same transaction. Okay, that is one. We have so the concept of time and same place is irrelevant, even if they occurred at different time and different connected to the facts in issue. And facts in issue, I have explained in previous videos, these are material facts. These are facts which are disputed. Okay, it is exactly what you're going to base your case on if you seek to prove or disprove a matter in court. Okay, so any fact that is so connected as to form part of the same transaction, that is also relevant and admissible. Facts which are the occasion, cause, or effect, immediate or remote, of relevant facts or facts in issue. Okay, so there are degrees here. The first one, any fact in issue is relevant. Okay, any fact that is in itself forming or explaining or proving a fact in issue is relevant. Then the second degree is facts which are not forming part of facts in issue, but they are so connected in such a way as not to be alienated from, okay, from the facts in issue, that you cannot seek to disprove or prove without them coming into the picture. So that is the second degree. Then the third degree is those facts which are related now or connected uh, to the relevant facts. Okay, so we have facts in issue, we have relevant facts, then we have those that are connected to the relevant facts. Okay, so there's like I can't say, okay, like a hierarchy, but more so like levels or stages or classifications. Now, any fact is relevant which shows or constitutes a motive or preparation. So then we come to a connection and same transaction, and fact which are the cause or effect, okay, of relevant facts or facts in issue. Cause effect is number two. Number one was so number one was connected, same transaction. Number two was cause and effect of relevant facts or facts in issue. We have the third one being under the act, those which constitute a motive or preparation. So in criminal law, where you are required to prove certain crimes, the intention or motive, that is the mens rea, the preparation being, of course, like for example, when we are talking about attempted rape or any attempted crime, the preparation is gonna be a huge material elements that it's a great element you're gonna have to prove here. Okay, as far as the preparation is concerned. So preparation, whether or not it was there, then that qualifies a crime to be an attempt if it wasn't completed or if it wasn't executed. But being there, preparation, so these are material things you can see, intention and preparation. So that is very relevant, especially in proving or disproving crimes. So that is motive or preparation. So those are very relevant, okay? Motive and preparation. I hope you're noting down at least these points that I'm saying. Then you can find your own cases as examples of each one. The So motive or preparation for any facts in issue or relevant facts. Okay, so the conduct of any party or of any agent of a party, yeah, to any suit in reference to that suit, okay, in reference to any facts in issue. So the fourth is this agency agency relationship. We have agents and principals, so the conduct of any agent of a party is also relevant as far as it is connected to any fact in issue or relevant fact. Then we have the conduct of any person against whom, okay, the conduct of any person against whom an offense against whom is what do you call, is accused of an offense. Okay, so we have agency, the conduct of any party including an agent, conduct of any party against whom a proceeding is being put up, the words are escaping me today, is relevant. So conduct is relevant if such conduct affects or is affected by any fact and issue or relevant fact, and whether it was previous or subsequent, whether it happened before the material fact or it happened after. So conduct is also very important. When evidence of the conduct of a person is relevant, any statement made to him which affects that conduct. So yeah, so statements which affect conduct, okay, made to that person also become in the present. What conduct does not include statements unless those statements accompany and explain acts other than sin. Yeah, this was what I remember reading this, and I thought, wow, this is one of the reasons why plain English was movement was initiated to just dissolve this quagmire of legalese. You don't know what it's trying to. The word conduct does not include statements unless the company explain acts. I remember laughing and posting about this particular statement, and still I'm perplexed by it. So we're not gonna dwell on that. So we also have other types of relevant facts, facts necessary to explain or introduce a fact and issue or relevant fact. Okay, so explanatory facts or facts which tend to explain the facts in issue or relevant fact. So explanatory facts, okay, or which support or rebut an inference. Okay, so any explaining that is required of the fact in issue or relevant fact, or any kind of fact which would otherwise support or rebut. Okay, so okay, other than that, we also have which facts which establish identity of a person. So the facts which establish the identity of anything or person whose identity is relevant or fixed time and place at which any fact and issue was done or happened, okay, or any relevant fact for that matter, okay, or which show the relation of parties who are the subject of the facts in issue. So you need to understand this. It's not confusing. You just need to note down those instances where facts become relevant and therefore become admissible evidence in court. Just look at the keywords issue, which explain which are material to a case. You need to or disprove them, okay, if you're acting for the plaintiff or the defendant. And then we move on to same transaction, condition and same transaction, then cause and effect, facts which cause or which are the cause or the effect of the material fact or disputed fact or relevant fact. And then we have motive and preparation, which is mostly in what do you call it, is critical or crucial in criminal law as you try to prove menstrual. Then we have agency relationships or facts with relationships between parties. Okay, we say next is explanatory facts, facts which you would use, okay, to explain the material facts or to support or rebut, okay. Identity, facts which try to give or establish an identity of the person or persons or fix the time. So time or place where material fact or fact issue happened or relevant fact happened. Okay. Or relation between parties who are the subject of the case, or who are connected or who are relevant to the case. So you just need to imagine all those scenarios, yeah, for where a case or a dispute could arise between parties, what they could say, what they would say to explain, okay, the disputed facts, how they would try to prove or disprove, what they would use, what would be required to be established, like identity, all those things, time of thing happened, the place, the relation between parties. I'm sure agency is very common because, like, disputes where you have someone acting on behalf of, or someone acting under the instructions of, okay, the employer. So all these things, all these are scenarios you can just imagine. So they are not anything, it's actually what happens. They are ordinary things, but you see, because of the language used in the Evidence Act, you would think they were in, or you know, worldly, you know, or some technical terms, but they are not. Now, what is reasonable ground to believe that two or more persons have conspired together to commit an offense? So, facts which prove conspiracy between parties, okay, that is mostly in criminal law, okay, so that is relevant, okay, you see. But the wording and the language use is like too long and technical. You would think they meant something else, but just that, it's just to show whether these two people worked together, they had the same purpose, the same, they wanted to commit the same crime, you know, or they had the same intention. Yeah, so it's just two facts which you would need to prove or establish conspiracy. Another one is facts not otherwise relevant are relevant. In which instances? For example, if they are inconsistent with any fact in issue or relevant fact. So if they are not consistent, yeah, so they are relevant. Why? Common sense. Because if I say I walk on two legs and somebody says, no, I only have one leg. So why it's not? It wouldn't be relevant until it became relevant, because it would change the narrative. If proved, actually, it could turn out I have one leg, you see, something like that. So facts which are not commonly or naturally relevant become relevant if they are inconsistent with any disputed fact. I killed, so and so killed so and so. Okay, one party is saying that. Okay, a fact that comes up showing that this person at this on this particular day at this particular time was couldn't have committed the crime because he was in South Africa attending a conference on climate justice. Okay, so that fact alone, the fact that him being there was inconsistent. I'm trying to explain, but gosh, if I get this wrong, you just have to understand. Yeah, just come up with your own examples. Now, inconsistency makes a relevant and irrelevant fact relevant, where it would be inconsistent with the the fact in issue. I like to say material facts, but the disputed facts, the ones I explained to you, or relevant fact, okay? Remember, there are degrees. We have the disputed fact, okay? Then the second degree is facts which are relevant, like the ones we have mentioned, any of them, okay? So there's that connection here from one, the big daddy, then the small daddy, okay? But then the third degree is this fact we are saying, which can be relevant because of their connection to the big daddy and the small daddy, or the big daddy or the small the small daddy. They don't have to be relevant to both of them at the same time, simultaneous. Yeah, so facts not otherwise relevant become relevant if they would go against or be inconsistent with any fact in issue or relevant fact. Number two, if by themselves or in connection with others, they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. So it's the same cheese, but then there's blue cheese and there's cheddar cheese. But it's cheese. You see, the point is the same. Anything which would declare, any fact which would declare the existence of or non-existence of a fact in issue or relevant fact would be relevant. Why? Common sense. Because you are trying to go against the grain. You are saying highly, it's not possible that this happened. Why? Because the person was in a crime. I'm trying to recall Netflix true crime documentary. Ted Bundy was Ted Bundy. I think I'm hoping you know who that is. He didn't have legs. He didn't have arms, so he would be immobile. Meaning, if such a fact ever came to be, it would be relevant because it would mean all the murders happening which were he was accused of happening to all these women, 150 or so women, would be improbable. How could he move in that specific time, that high number of victims? How could he have moved in those several locations? How could he have moved from place to place? See, so it would have declared it highly improbable in what I'm trying to give you. Yeah. So moving on to another type of relevant fact in suits in which damages are claimed, any fact which will enable the court to determine the amount of damages which ought to be awarded is relevant. Yeah. So this makes sense. Now it's like all these facts. Remember, the Evidence Act applies cross-cutting criminal and civil. So even the definitions of what constitutes a relevant fact, you need to keep in mind. Like I said, imagine all the scenarios you were ever taught in undergrad. Okay, from torts to criminal law to whatever other law there is there, commercial. So imagine contracts, imagine true crime, bandy, imagine all these things in your mind as you read through them. Then they won't be technical. Like in this case, we went back to civil, which is commonly cases where we have accidents, we have all these, injuries and torts. So just imagine this scenario while you look at relevant fact number 12, in which damages are claimed. So any fact which would help the court find the amount, okay, of damages, were they called exemplary damages? Or not I don't know really. I forgot. There are general damages, then exemplary, and which other ones? So yeah, so those ones specific amount of damages, that facts would be relevant because of course making sense, it would help to find be compensated where the existence of any right or custom is in question. The following facts are relevant. Okay. Any action by which the right or custom in question was created, claimed, modified, recognized, asserted. Okay. Yeah. I'm trying to imagine a scenario which would 13 where the existence of any custom, any rights, anything commercial, and yeah, I'm thinking contracts here. We have kind of rights, we have modification, asserting through, asserting the rights through, let's say, through terms and conditions of the contract. Yeah, so any transaction by which the right or custom was created. It could be the sale of certain products which you realize with a contract written in this case, like the which act was that? Was it the law of contracts? How can I forget everything? Was it the law of contract act? Is there such an act? Or the what? Just give me a minute. My goodness, no, this is not possible. Section 3 of saying that that was contract in relation to land. So where they say contract in relation to the sale of land, just law of, this is not right. So law of contracts, yeah, the law of contract act, I was right, my God. I should stop doubting myself. So was it section 3 which said any transaction related to the sale of land should be written and what. I remember in conveyancing, that was like the most, what do you call it, basic thing anyone should know. So now that is one. We said any transaction could be the sale of land, whatever, that could have asserted the rights, created the rights in the first place. That is relevant. Number 2, particular instances in which the right or custom was claimed. Okay, recognized, disputed, asserted, or departed from. Tomatoes, tomatoes. I think A and B, I don't see the difference, but maybe you do, which is good for you because I already said for this and passed. So let's move on. Now, this is section 14. We have facts showing the existence of any state of mind, such as intention, knowledge, good faith, negligence, rashness, ill will, or goodwill. State you call the insanity, difference of for like yeah, when it comes to so state of mind is actually very important. So any fact which would explain the state of mind. I think I am remembering a case. Was it McNaughton, if I remember? My God, my memory is not helping me today. Let me just check. I think that was the major case for, was it the defense of insanity? McNaughton. Jesus. Rules which explains the unsoundness of mind incapable of knowing the nature of the act. So yeah, that's like the hail, whatever this to call it, this defense in criminal law of unsoundness of mind, insanity. So it comes like it becomes common sense, whichever fact which would at that time point out as to or establish the soundness or lack of the sound, lack of it, okay, would become relevant. Yeah, of course, where the question of the state of mind is in issue or relevant. Yeah. So number 2, a fact relevant within the meaning of subsection 1 as showing the existence of a state of mind must show that the state of mind exists in reference to the particular matter in question. Yeah, so the specificity is not general, where upon the trial of a person accused of an offense, the promotion by offense is relevant within the meaning of subsection 1. The previous conviction of such person is also relevant. So we have previous conviction where it is important to establish or where it would affect the case, where that record would likely affect. So where upon the trial of a person accused, the previous commission of the accused of an offense is relevant within the meaning of subsection 1, which we said they would show the state of mind or habits or patterns. I remember a case, but it's not in my mind. This is gone, like totally erased, evaporated. But I remember a case where this the person's previous commission of an act was used to establish his guilt in the current case, to point to us to his guilt, to his guiltness. But is that even a word? So there's like a pattern of behavior or a habit or something which the court would use where a previous commission comes into question. So that is very important. That's why good conduct, certificate of good conduct is very important. When there is a question that was accidental or intentional or done with a particular knowledge intention, the fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. Wow, whoever wrote this is probably having pleasure, gaining so much pleasure from our pain right now. To solve this puzzle of and technicalities, when there is whether it was accidental or intentional. So unless it arises, it becomes in question whether the act is accident or intentional. So it's the same thing I was trying to explain. Where an act that was performed, there are a series of actions or similar occurrences. It happened, or this person did not have a series of actions in the act was concerned. So the person is in question, okay? And this person has been known to have done a series of actions of similar occurrences. And the question on the table is whether he did this an accident or intentional. Whichever series of actions or occurrences he has done of similar nature before or during that time. Okay, they want specific here. I'm guessing would the court is use that to establish whether to establish intent or lack of, in this case mostly intention. Now in jurisdiction based on the English law, evidence must conform to a number of rules. So this now is Steve. He is trying to explain. Should I call him Steve or Dr. Steve? Let me just see. Graduated LLB. I think he's a doctor. Oh, he was a candidate by the time. Let me just give him the respect. Dr. Steve. Now he's trying to explain what we've been reading was verbatim from the Evidence Act. That's why we needed an extra brain to internalize those sentences. Now we have him explaining to us, which is wow, with cases and amazing, so we can understand. Yeah, let's just go. Let me just see how long this is. Oh, it's not even long. Oh no, let me just. Okay. So we have what we have. Him explaining what I basically told you before, that there are rules when it comes to evidence. Not all evidence is admissible. Then we said, oh, okay, so what evidence is admissible? Say those must be facts which are issue or related to the facts in issue, which are called relevant facts, or facts in the third degree, which are connected to the relevant facts. Okay, baba mkubwa, baba mdogo. Okay, so just remember that. Then we have the main thing in mind is relevance. That's the whole deal. Evidence must be relevant to be admissible. All right. Yeah. Evidence, if it does not prove the existence or non-existence of a phantom, is relevance, means admissibility. Lack of it, no admissibility. A fact may still be relevant even if not an issue where we say in the first instance we transaction and connection. Similarly, facts which result from relevant facts are relevant and therefore admissible. So you see, that is what we are trying to say here. I don't know what's wrong with my internet. It keeps on disconnecting. All right, so we move on. Yeah, the first rule is that it must be relevant. That's what we say. For the evidence to be relevant, those facts which are subject to being proved or disproved must amount to, number one, facts in issue, fact, and collateral facts. So those are the 3 degrees I was telling you about. Did I call him Big Daddy? Secondary and the third daddy. Collateral facts which may, for example, affect the credibility or competence of a witness. Okay. Now, however, the relevance of evidence is ordinarily a necessary condition, but not a sufficient condition for the admissibility of evidence. For example, relevant evidence may be excluded if it is unfair, prejudicial, confusing, or cumulative. Okay. We said evidence, in order to be admissible, it has to be relevant, but not all relevant evidence will be admitted because the court can refuse to allow evidence which is otherwise relevant because it is unfairly prejudicial or confusing or cumulative. Or cumulative, in a sense, I would think you have a set of many relevant facts trying to prove the same thing. Yeah, so it's like piling the same. So Stephen defined the word relevant as to mean any two facts to which it is applied are so related to each other that according to the common core of events, one either taken by itself or in connection with other facts either proves or the presence or non-existence of the other. So see that of which are relevant, these facts are so connected that they could stand on their own, okay? They could stand on their own to prove or disprove, all right? This definition has this merits, okay? So relevance is concerned with the relationship between facts oh my god, I'm sorry for the noise. I don't understand why the people are outside and all right, so basically relevance here Dr. Steve is trying to explain what relevance means. Mm, mm, okay, so it's all about the relationship between the fact that you're trying to use that is seeking to be proved or disproved, okay? Any what do you call connection in the identity, okay, proved in the all those things we had said, form, yeah, in the state of mind, mindfulness, yeah, state of or soundness of mind is in issue, all right? This thing is basically trying to prove that. So we have another definition of relevance by Lord Simon Grace, who said everything relevant if it is logically probative or disprobative, meaning if it could prove or disprove a matter which is in question, okay? Which is now the issue now. Yeah, so basically this same definition, whether a fact would make the fact in issue less probable, you know, or more probable. Could it have happened or not? Okay. The likelihood, increasing the likelihood of a fact in issue, of its existence, whether it is true, it's there, or it's not. Okay, those are relevant facts. So there's more technicality here. Yeah, so it's just the same points, but it's explained in various methods. Yeah. So then we come to res gestae, relevancy of facts forming part of same transaction. In terms of section 6, a fact which, though not in issue, is so connected with the fact in issue as to form part of the same transaction is relevant and therefore admissible, as well as a fact which cause, affect, or afford opportunity for relevant things to happen are relevant and admissible as gesti. Did I pronounce that? Let's see if we pronounce that correctly.
So how do you say it? Well, we can say it one few different ways actually. First word in English can either be said as raise or weeks. Two different pronunciations for it. The second word can be said as gestai or gesti, gestai or gesti.
Gestai or gesti. So res,
Gestai or gesti.
res, gesti or res, gestai. So we are not so far off. Now, relevancy of facts forming parts of same transaction are called res gesti. Res gesti. Res. Okay, now that is cool. Res gesti. Res gesti. Yeah. So those are the ones. Now, we have Lord Wilberforce is explaining in when a situation of fact, for example, killing is being considered. The question may arise: when does the situation begin and when does it end? So it may be he's saying it is gonna be the way to just confine the evidence of the gun or the knife without knowing in a broader sense what was happening, and that is where res gesti comes in, or comes in. It comes in as that as facts which become relevant because they are so connected with the issue as to form part of them. Okay. Now, yes. So what was happening is the question. And then he explains further that in all Larry versus regime, I think that's regime means the regime, I don't know. Evidence was admitted of assaults prior to a killing committed by the accused doing what was said to be a continuous orgy. I don't know why he was. Okay, so we have evidence of assault, assault, assault or assault, assault. This person assaulted, okay, the victim, okay. As Dixon said, without evidence of what was done at the time, those men who took any and the evidence, the behavior, the transaction of which the alleged matter formed, integral parts could not be fully understood and isolated from it, could only be presented as an unreal and not very intelligible event. So this explains that a fact, even if it's not an issue, if it is so connected that it cannot be separated from the material fact, or you cannot prove or disprove that facts in issue without using that, without those events or actions forming rest time. Not prove, okay, those facts become relevant. I don't know which other way I can explain. He's going really deep with this. The rule is Okay, so it's also an exception to the hearsay, the general rule on hearsay, which is that hearsay evidence, that but evidence is not admissible, that person must be available. I did a video on hearsay evidence. That person you had saying that must avail himself. Hearsay evidence, there are like many exceptions, such as if it's too costly for the person to be put to court, the person is dying, bed, something like that. And maybe they're unconscious. I don't know. There are so many. I remember there are so many exceptions. Yeah, for general rule, there's an exception. So there are so many exceptions here, and one of them was res gestae, and this is how it comes in here. They explain that where a fact is so connected as to form part of the same transaction becomes relevant and admissible. And the rule, of course, is that there must be some time or some, what do you call, some immediate, it's not, is it proximity, not proximity, like there shouldn't be a big gap between that event and the, okay, as to render a fabrication. Yeah, this really happens. I'm seeing this happening in the case where you're trying to prove, you know, for example, there's this case that is coming to mind as an exception to hearsay, where the person tried to mention the name of the one who had killed him, supposedly the person, his killer, and he tried to say the words or the names. Was it Pius? I don't remember. Let me just see which case that was of time. This case where he tried to mention the name, and yeah, it was Pius. Was it Pius? Ah, I don't know. There's a case where somebody tried to mention Pius case. I can't see it, but I think it was. Yeah, so when he uttered those words, of course, the person who was alive then, the person is dead, no longer available to stand in court and say who killed him, but there was someone standing and he had them. So I think that qualified as an exception. He had him say, that person is not available. But the time he said, there were two cases in comparison. One where that person had said and like months had passed by. So that gap was not, the court did not allow that. Then there was one which was only, I think, a matter of a few days or hours, I think. I don't remember. Oh, excuse me. So basically, it's just the same, like on motive and preparation and conduct. Yeah, we said in criminal law where you are trying to qualify an act as an attempted crime, attempted rape, they would look at the motive, they would look at preparation, even if you didn't follow through with the act. For example, where the case is about a person who accosted a young woman who came from the bar, maybe in the very late at night, and he just came from nowhere and jumped on her. And of course, the level of the intention was there, from the jumping on the woman and trying to rip the skirt. Okay, maybe he did rip the skirt, and even he did like undo his pants. So that kind of preparation, okay, and the intention, I think those would amount to preparation and intention and motive for doing, for raping. Yeah, so he didn't go through with it. Then maybe a bunch of other girls showed up who were friends to the accosted young woman after she screamed for help, and they all came, and the guy couldn't finish or couldn't do what he was doing. But don't take my word, because I'm also mixing that with the case of kidnapping, where you are found in the scene. Okay, you already have your tapes and your ropes and everything. But there are very technical rules there when the court will look at. And as far as rape is concerned, I don't know whether they would require actual penetration, or at least that contact between the parts of the victim and the perpetrator to qualify as preparation, yes, and thus attempted rape. So there are technical, but that is for further reading on your part. I remember that was the most interesting topic in criminal law, where you try to establish the existence of attempted rape, attempted kidnapping, and other things. Yes, excuse me. Yeah, so yeah, basically it's just, yeah, it's more explaining. Even Dr. Steve here has explained, in the case of rape victims, the complaint of the victim, if made at the earliest possible opportunity, is relevant. This principle is applied to victims of rape, indecent assault, and other similar offenses under the criminal law for the purpose of credibility of the story, or for negating pleas of consent. Okay. Complaint of victims is not relevant in other cases. The provision is read in Section 8 and refers to all complaints. Okay. So see now, this complaint becomes relevant to negate pleas of consent. So where consent to the fact that the victim made a complaint in as early as possible, that itself becomes relevant to negate this. Yeah. So those facts we say of motive, and conduct, apparently consent as well. So we have explanatory facts, the ones I said I used to explain. So this deal with facts necessary to explain or introduce relevant facts. Okay. So here we have the issue of the various examples of identification parades. Okay, so basically, I don't know what he's trying to say here about code B. I think I need to read more of this. I remember it's also PM identification parades, but I choose that question, thankfully. No, I didn't. How could I choose something? I wasn't great at. So yeah, so move on to section 10, statement on intention. Which one is yeah, this is piracy. Yeah, there was conspiracy between case, that is the position in England, whereas in Kenya there's a common intention. In England, an additional requirement. Okay, so it's technical terms and definitions. Now that is so technical. Yeah. So where there are any proof there is conspiracy, or that as a party has committed any act in furtherance of the common intention, okay? Then Dr. Steve is trying to explain what it means to say in furtherance of as opposed to with reference to, and how those two might be different. And I'm not going into that because I'll be explaining the nucleus and electrons and whatnot of English language. Now 7, okay, so we have facts inconsistent with or affecting the probability of existence or non-existence of a certain fact. This we said where any facts, its common sense would come up, which would make something less likely to have occurred or more likely to have occurred, or just simply be what is in question or what was asserted, it becomes relevant, okay? I'll give the example where somebody the question of the facts in issue was whether committed a crime. Sorry, Ted Bundy had killed all those 150 women or plus, but the fact that he during that time was attending a conference in South Africa on climate justice at that material time, okay, that fact would be inconsistent with the fact saying he committed, or the facts in issue, or the question which was whether he committed the crime or not. So you see, that is just an example. Now the question of distance, the question of place, all those would be relevant where he was at the time, okay? And then we have, of course, the question of alibi, and okay, and then I also gave the example of to explain this type of relevant facts of inconsistency or probability, whether Ted Bundy could have committed all those crimes had he been blind, and had he not have any legs or arms. Then the question would be the distance, how he approached those 150 plus women. It would have made it less probable, okay, that he was the killer of those women. It would have affected the probability that he could have killed all those 150 women with no arms or no legs and no set of eyes. How did he move? how could he have approached them, how, so those questions. So basically that is all about relevance. All right, it's very important because somebody had requested it, and of course I'm sure we had gone through this, but I didn't mind to do this video again for the person. I don't remember who that was. Let me just check. But I want to I wanted to say thank you for watching my videos, and I'm open to receiving receiving any requests you guys may have. Okay, just feel free. Of course, for now I'm preparing for my research for legal practice management, so I'm trying to read and revise because I don't want to waste time or wait last minute. But whenever I get time or those breaks in between, I'll be happy to answer to your requests and make these videos, even if they are short. But I'll make sure at least you get the main points. Okay, at least I'll make sure that. So I don't want to be I don't want to deny you guys. I don't want to deny you at all. Yeah, so where was I? Yes, I was trying to find the name of the person. The person who had requested. I don't know. I can't see. Please bear with me. This is taking forever. Ooh, it's taking forever. I don't know if I'll be able to find this person. Oh yeah, I'm in a check. Oh God, this is just taking forever. Yes, I found. Yes, it was Winnie. A nice piece, a nice presentation. Do another for admissions and relevancy. Yeah, so that is Winnie. Thank you so much for commenting and for watching my videos, and I did this for you. I hope you find it I hope it helps you. The next thing I'll do is admissions. I wish I could just tell you which video that was. I'm sure I did admissions. I can't remember for now. Maybe let me just check in my library and then I can just tell you. All right, you can go and access it. I am sure 100% I did admissions. Let me just check. Admissions. Yeah, so I did a video 7 months ago on admissions in the law of evidence. Let me see if I can get, like, copy this and can show you. So if you go to my playlist on commentary on the evidence on books, it's books playlist, I think. Which playlist is this? Let me just go to playlist. Is it books? Yeah, I think it's books. Yes, if you go to my, no, it's not books. Gosh, where is it? It's not under books. It's under, yes, it's the playlist, a commentary on the Evidence Act. So I did just go to my playlist and choose a commentary on the Evidence Act playlist. Go down, you'll see several videos I did on judicial notice, presumptions, burden of proof, confessions, and then I did admissions. You will find it there. Yes, Winnie, thank you so much. And bye-bye. See you next time.